welcome to be with us once more on our Becoming America show. This is Judge Jim Gray, along with my partners, Dr. Joellen Chatham, as well as the Honorable Bijan Kian. And we're in our 6th edition. Things move along, but we are talking about today as our theme, Remember the Ladies, as well as Article 3 of the Constitution, the Judiciary, which is in a lot of ways, at least in my view, and we'll look and see if our guest, Congressman Tom Campbell, agrees, is a lot of ways the most important of our branches because it protects our minority rights. So we're getting into this. We're talking about, of course, the Constitutional Convention from 1787, and we're basing this. There were 17 songs in the musical that I wrote, which is called Convention, the Birth of America. I wrote it with 2 partners, Steve Lawless and Joe Henry Stein, but it talks about the delegates, it talks about the situation, it talks about certainly the issues. So we meant to educate, we're meant to provide pride in our background of our country, as well as, of course, have a lot of fun along the way. So that's kind of what we're doing. It is with me, my co-host, like I said, and I'll tell you a little bit more about Tom Campbell. But first, like we always do, we will play our song to kind of introduce the theme. It's called Remember the Ladies. And I almost never say founding fathers. I say our founders, because many of our founders were women. And certainly prime among those was Abigail Adams. And I take very little credit for the lyrics in this song, Remember the Ladies, because most of them are direct words, quotes from Abigail Adams. She will talk about, and she had some supporters, and you'll see in the song, or you'll hear it, a lot of them were agreeable with her. Oh, we should be active in the busy world. Now, it's not business, but busy world, just like the men, they said. And then they would say, well, she says we should also get an education. They say, well, just like the men. And then she says the audacity, and we should be able to vote in your elections. And the response is, just like the men, sort of thing. So that's where we lead into this, and then we'll talk a little bit more. But first, like we always do, let's give a listen to Remember the Ladies, song number 6.
All men would be tyrants if they could, but tell them it must be understood that it would be very, very good to remember the ladies. Be kinder to them than to your ancestors, gracious to us for peace to be yours, so that our great nation endures. Remember the ladies. We should be recognized for our own intellectual activities, just like the men. We should have privileges and the right to own our own property, just like the men,
just like
and earn an education and travel as we please, and maybe even vote in elections,
just like the men.
Just being companions, we're not content, so I will make the argument. Your time would be excellently spent remembering the ladies. It's hard to conceive of much elation without a voice nor representation. So won't you please hear our frustration? Remember the ladies. Women are suited to care for their homes and their families, but we ladies can be involved in political debate,
Just like the men, just like the
and
men.
we can be effective in the busy would be tyrants if they could, but tell them it must be understood that it would be very, very good to remember the ladies. Be kinder to them than to your ancestors, gracious to us for peace to be yours, so that our great nation endures. Remember the ladies. Remember the ladies. Remember the ladies.
So, Joellen, you are our historian. You are a lady, of course, and you know a great deal more about the Constitutional Convention and those times than I do. But back then, what was the role of the women in the 18th century? How did they come out with regard to the Constitution as it was written in 1787? And then how does it come out thereafter by various amendments? Because that's what our theme is today. Joellen, take it away.
Well, interestingly, the role of women depended on whether you were married or not. If you were a married woman, your legal status was under this concept called coverture, meaning you were covered by your husband's legal status, and married women had no independent legal or economic status of their own. If you were unmarried, it was a different story. And in fact, when the Constitution was written, if you were a woman and you had at least 50 pounds worth of property, you were eligible to vote. So the status of women was different. I think sometimes we have a jaundiced view of what it was like to be a woman in the 18th century, that they were shoveled off into a corner and told what to do. That's not true. The life of women at that time was often much more exciting and interesting than we know. It was often more dreary than we realize. It was also more complicated. If you look at the Revolutionary War period, women were very active. They were managed businesses and farms while their husbands were away fighting, and that went on for a number of years. They led boycotts of British goods. When we boycotted British tea, it was the women who came up with a new concept of liberty tea. When we boycotted other British goods, people started wearing clothes made out of homespun instead of imported materials. That was all done by the women. During the war, they made uniforms for their husbands. They often followed their husbands to war and clothed them and fed them and cooked for them, bandaged them. So women were actively involved. They melted metal for bullets. And we all know the story of Molly Pitcher. When her husband fell, had his cannon, she was at his side and she took up his role. Molly Pitcher was only one of many women, some who actually dressed up as men and pretended to be men, who fought in the Revolutionary War. In addition to the war itself, women were often partners in their husbands' businesses. The husband may have had the legal responsibility, but they couldn't have done it without the women, including farm life, frontier life. Women operated ferry boats, they operated prisons, boarding houses. In fact, the most popular boarding house in Philadelphia during the convention was Mrs. House's boarding house. Women were teachers, they were preachers, they were storekeepers. So women had a much more varied and interesting life than we realize. But what is so interesting is when the Constitutional Convention was held in Philadelphia, the delegates, who were all men, didn't discuss women. They really didn't discuss Indians, they did discuss slaves, but we really weren't discussed at all. But that's not a problem because the Constitution is completely sex neutral. It speaks of ambassadors, senators, representatives, electors, judges, but nowhere does it make a distinction between men and women. And a colleague that I taught with many years ago at West LA College just couldn't understand why I personally didn't support the Equal Rights Amendment. She said, "You couldn't even be president under the Constitution." And I said, "Where does it say that? You just have to be 35, a citizen, for a natural born citizen. There's nothing about gender in the Constitution." So the question becomes, then why did we need a 19th Amendment to give women the right to vote? The 19th Amendment didn't give the women the right to vote. The right to vote was already held by women in 15 states, almost all of them west of the Mississippi, where frontier life in the West showed what women can do, and women were really appreciated. So why did we need the 19th Amendment, which, by the way, went into effect on my birthday about 26 years before I was born, but it was on my birthday anyway, August 26th. The Constitution gives the states the right to determine voting qualifications. And for most of our history, the states exclude women from voting until Wyoming in 1869, when the governor of Wyoming signed a law giving women the right to vote and to hold office. Other states followed suit. What the 19th Amendment did was actually place a restriction on the states. And it told the states, when you are defining voting rights, you cannot exclude people on the basis of their gender. So the Constitution, perfectly sex neutral, it was an imposition on the states that assured that women would not be discriminated against by the states in voting rights. I think most of the voting rights that women have, not voting rights, but legal rights in general, have followed the culture. For most of human history, women took care of the home and men took care of the outside world. A lot of that was dictated by biology. I think what has given women more freedom throughout history is technology, because making a home with microwave ovens and dishwashers and vacuum cleaners has made keeping a home so much easier. It's allowed women to have other interests outside the home. Men still have to go out and work as a rule, so technology hasn't done enough for you guys. But technology has really changed our culture. It's changed roles between men and women, and the law has followed that, but generally not through amendments to the Constitution, but through challenges to laws that made a distinction on the basis of gender. And I think that's what gets us into our subject with Tom today, because where do you challenge laws based on their discrimination? You challenge it in court. And of course, Ruth Bader Ginsburg, who was a long-term member of the United States Supreme Court, was a champion of women's legal equality for decades before she was appointed to the Supreme Court. But it's the courts where the changes were primarily made, and often legislatures began to change the law just because of the culture, but the real challenge came in the courts.
Joellen, I saw a cartoon just, I think yesterday, that showed a woman applying for a job, and the man interviewing her was saying, you know, if you get this job, you're going to take the place of 5 men. And she said, oh, that's really disappointing. I was looking for a full-time job. And I think that you pretty much explained that as well. But we are blessed today. We in all of our sessions, pretty much, we have a guest. It's not an accident. We find some really articulate, experienced, sophisticated people. And today we top that list because we have Tom Campbell with us. And I can tell you directly, he's my good friend. He has the most intimidating resume of anyone I think I've ever met or ever known. He was the valedictorian of his high school class in Chicago. Then he went to the University of Chicago and got a degree in a BA, an MA, and eventually a PhD in economics, all with honors, went to Harvard Law School with honors, and then actually became a clerk for Justice of the Supreme Court, Byron Whizzer White. Talk about a mentor. I'm sure he was mentored there. He was also mentored by his father, who was, William Joseph Campbell, who was the chief judge of the U.S. District Court in the Northern District of Illinois. And I'm now really enamored with him because he was also mentored by one of my true heroes, Milton Friedman. Thereafter, he became the director of the Bureau of Competition at the FTC, the Federal Trade Commission under the Reagan administration. Thereafter, of course, was a member of the State Senate in California, member of the U.S. Congress from Palo Alto, California for five terms of 10 years. Then he also was the dean of the University of California at Berkeley Law School, pretty impressive, then the dean of the Chapman University School of Law. So all of this is really pretty strong stuff. I'm setting him up for really setting you up, Tom, because you do have one of the most interesting, sophisticated gentlemen that I know, but I haven't gotten to 2 more really qualities. qualifications. One is he is the author of the book, Separation of Powers in Practice. That certainly gets him into our topic today of the judiciary. And now the strongest of his credentials, he's married to Suzanne, who is a wonderful lady. So as you know, we name ourselves, I'm Judge Jim Gray. They call me the judge. We call Joe Ellen, for good reason, the professor. We call Bijan, for good reason, the American. And I think we should call Senator, Congressman, Dean Tom Campbell, your eminence. But with that, Tom, welcome. Thank you for being with us, and share your thoughts a little bit with us with regard to the judiciary. Was it a part of the Constitution? We didn't have a judiciary, as I understand it, national judiciary, until the Constitution of 1787. Fill us in a little bit, Tom. I'm at your beck and call.
Thank you so much for having me, and thank you for that most generous introduction. Judge Gray, you and I have in common being the son of a federal judge. So we both know the experience of growing up in a judicial family. And I don't know if it was like this for you, but one would have to make pleadings before my father. And the opposing side was frequently given the chance to rebut. And being
Tom,
one of 8 children.
Tom, probably like you, I didn't win many arguments in my court with my father. I came out second almost always.
There was, however, a court of appeals. I don't know if that's the case, but my mother's mother, my grandmother, lived with us. And so if necessary, an appeal could be taken. Joellen, I loved your presentation, and thank you for all the research behind it. One quick correction, lest I be flying under false colors. I was the dean of the business school at Berkeley and the dean of the law school at Chapman. So it was the Haas School of Business at Berkeley. Joellen's presentation regarding the status of women under the Constitution, it directly invokes the power of the third branch, because the third branch, the judiciary, interprets the phrasing in the 14th Amendment that no state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person the equal protection of the laws. So those phrases are general, as a constitution ought to be. And for most of America's history, they did not prevent states from having men-only franchise. The question that arises in Joellen's presentation, which she put succinctly, is why was there a need for the 19th Amendment, which prohibited states from excluding the right to citizenship or the right to the franchise on the basis of sex, if there was already a 14th Amendment. So 1920, on Joellen's birthday, as we understand, August 26th, the 19th Amendment became constitutional. But in 1868, the 14th Amendment had already become part of our Constitution. And the 14th includes the phrases that I just quoted, that no state shall deprive any person of the equal protection of the laws. So isn't denying a woman the right to vote a denial of the equal protection of the laws? And the issue was evidently not even in doubt that the 14th Amendment was not considered a guarantee of that right, that a state that denied a woman the right to vote was not denying equal protection of the laws, and hence there was a need for the 19th. That becomes important when the Supreme Court in the 1970s begins to put content into the phrase equal protection of the laws regarding gender. So let's go back now to where the role of the Supreme Court is. The Constitution sets up the Supreme Court. It does not say that the Supreme Court shall be the final arbiter of the Constitution. However, in 1803, in a very famous opinion by Chief Justice Marshall, the Supreme Court unanimously held that in that cases involving application of the laws would inevitably get into the courts, the court had to determine whether the laws under which an individual was suing were comported with the Constitution or not. The opinion by Chief Justice Marshall says it's inherent in the logic of the third branch where you bring your cases. If you were to bring a case under a law that was unconstitutional, Chief Justice Marshall said, and the Supreme Court chose not to strike down that law, then what would it be? What would be left of the justice's oath to uphold and defend the Constitution? He explicitly ties it to the oath that the Constitution requires justices and judges and all officers of the federal and the state government to uphold and defend the Constitution. So the logic of the third branch being the place where individual rights are litigated requires the court to determine whether a law is consistent with the Constitution or not, as does the oath of office. Lastly, I see great value in all three branches upholding the Constitution. And this is a main theme in my book that you were kind enough to mention, separation of powers in practice. Our country, our democratic republic is served best when all three branches ask before they take an action, is the action we contemplate constitutional? So if a law is being proposed, and I can give you examples from when I was in Congress, one law by a well-meaning colleague said, too many delays by these judges in reaching opinions. I tell you what, let's cut their salary, federal judges' salary, if they don't issue an opinion within 2 months after the case is settled or decided. No, the Constitution prohibits the diminution of a federal judge's salary. So hopefully the Congress itself would step in and stop. And if you like, I can talk about the flag burning cases as well, where other members of the House and Senate proposed that we put people in jail for burning the flag. And others said no, that violates the First Amendment. Okay, so the Constitution doesn't say the Supreme Court alone shall apply the provisions of the Constitution, but the other branches can as well. It's just that the end of any litigation is in the court. And I should mention my very last point on this, the executive also has an authority, has the authority, but I should say the obligation to constrain his or someday her exercise of executive authority to comport with the Constitution. And I am sorry to see that this has not been the case by Democratic and Republican presidents. One of the abuses, in my view, in recent years has been the so-called signing statement, where a president will sign a law that the president believes to be is unconstitutional, but then writes a statement saying, look, I need the law otherwise. So it's a defense appropriation bill. So even though it curbs my powers regarding recognizing foreign countries, that's the case of Jerusalem, which we can talk about if you like, even though it's unconstitutional, I'm going to sign the law, it'll go into effect, I'll just ignore that part of it. No, no, no. If it's unconstitutional, you, the president, should not sign the law. You, the Congress, should not pass it. But if both of those two fail, then the last guardian is the Supreme Court.
Tom, we're going to spend another session with you in a few weeks where we really get into separation of powers and how complicated it is and overlapping it is, and whether or not sometimes one branch of government has overstepped. But you've brought up a really important point about interpreting the Constitution. We hear words all the time about judicial restraint and judicial activism. Can you discuss those two concepts and how they conflict?
They do conflict. The Constitution's words are our best indication of the Constitution's meaning. If you stick with those words and do your best to understand what they mean in the context of when they were approved, you then have a safety against a justice or a federal judge at the lower level, but eventually a justice, simply applying her or his policy preferences. And since judges, federal judges and justices are not elected and serve for the duration of their good behavior, which in almost all instances is until they retire or until they die in office, it's critical that they restrict themselves to the words and intent of the Constitution. That's judicial restraint. Judicial activism takes a different point of view. and it has its adherents in academics and legal scholarship and on the court itself. And the legal activists say the Constitution sets up general principles. Do not be overly concerned with the exact words that the founders used or subsequent authors of the constitutional amendments used. Instead, derive their fundamental purpose and then vindicate that purpose in the modern context. So to give that side of the argument, with which I generally disagree, but to give that side of the argument its best example, the Constitution forbids unreasonable searches and seizures. And of course, the time when that was written, in the later part of the 18th century, there was no electronic means of intercepting conversations, either by remote or telephone tapping. So therefore, is it permissible to tap a telephone conversation without obtaining a warrant? The judicial activist would say clearly not, because the intent of the Fourth Amendment was to protect privacy from intrusion by the government. And so it would be absurd to say only thing that will be prohibited is if a police officer is literally dropping under the eaves of the house in which a conversation is taking place. The originalist would not have much difficulty with that because the phrase is unreasonable searches and seizures. And so the traditionalist would say what is reasonable naturally requires consideration of the circumstances, and technology is part of that. But where the originalists go, where the activists go off the rails is when they interpret a phrase, no, should only person be deprived of life, liberty, or property without due process of law, to say that, well, liberty involves the freedom to marry somebody of my own gender. That would astound the founders, it would astound the authors of the 14th Amendment. But an activist would say, well, liberty changes over time, and so to interpret what liberty means is the duty of the Supreme Court. And that view was most championed by an appointee of President Ronald Reagan, Justice Anthony Kennedy, who retired from the court just a few years ago. So those are the two schools. There's no perfect clarity between the two, as you can see, but I would call them inclinations. The inclination by a justice to use a phrase such as undue or reasonable or freedom or liberty to import her or his own meaning, and the inclination of a judicial conservative to restrain, realizing that they, after all, are not the repository of the mores of the people, rather the elected representatives are.
Well, Dean Tom, I've been involved in this, not in the depth that you have, but I've always pretty much inferred that judicial activism and judicial restraint are basically in the eye of the beholders, that if I am one or the other, I certainly am reading the same Constitution and I just come to a different logical conclusion. So I kind of hold it against, for example, the framers of the 14th Amendment. They didn't anticipate the airplane. They didn't anticipate the internet. So, how are you going to provide and apply the 14th Amendment from 1568 to the airplane or to the internet or to our cell phones, et cetera? But it is a living tool. It's in the eye of the beholder. Do you think that Brown versus Board of Education prohibiting segregation in schools was judicial activism or judicial restraint? What about the penumbra of the Constitution that has now given us the right to privacy? Just kind of, a lot of them I think are outcome oriented. Do you share my cynicism?
No, I don't share your cynicism, and I don't think you share your cynicism. I think you are an optimist and a patriot. So let's deal with the Brown versus the Board. Clearly straightforward application of the 14th Amendment. Judicial restraint is fully in evidence in striking down a state's decision to give different education based on race. The 14th Amendment says equal protection of the law. It couldn't be closer. And it was in the context of the freed slaves that the amendment was passed. The mistake was Plessy versus Ferguson, which had allowed states to claim the euphemism that the provisions were separate, but they were equal. And with the Supreme Court, and that was, as you know, subject to a very strong dissent by the first Justice John Marshall Harlan. And in his dissent in Plessy versus Ferguson, he said, the Constitution is colorblind. Equal protection means you cannot say blacks in the back of the train, blacks in this part of the station, blacks in this school, and whites elsewhere. So the judicial activist was the court in Plessy versus Ferguson that said, despite the words that no state shall deprive any person of the equal protection of the laws, it will be okay to have race-segregated public services.
You may have answered this question before, but I'm going to ask a question that may be on the minds of some of our viewers in a different angle. Nominations to the Supreme Court have become extremely contentious. Now, we all know that they say legislative branch makes the laws, the executive branch executes the laws, executes the laws, and the courts interpret the law. You've been talking about judicial activism and the originalist view. I'm going to frame this question a little bit differently. What does it exactly mean to interpret the law? What are the boundaries of that? I'm sure our viewers want to know, is it like Judge Gray explained, is it just purely a personal view? In that case, how is it reconciled? What does exactly interpreting the law means, especially when the court has actually made law? It's gone beyond interpreting the law. I guess we could refer to the case of abortions, decisions on abortions, and also prayer in schools. What are the boundaries of interpreting the law by the Supreme Court judges?
Chairman Can, you're right that the temptation is great to characterize a decision you disagree with as creating the law, and when you disagree, and when you agree with as simply interpreting it. A test would be this: can you see a case where a judge or a justice rules in a way that the law compels, even though she or he does not like the outcome? And I'll give you a very specific example. Justice John Paul Stevens, in his decision striking down the conviction of a Texas citizen for burning the flag. Justice Stevens was a veteran of World War II, a distinguished patriot, and he said, "I abhor the burning of the flag. It is such symbolic and important value to all of us, particularly those who have family members who were killed in action, to whom the flag is given at the funeral." So I wish a different outcome. I wish I don't have to decide this way, but I do. Burning the flag is an expressive act. It is covered by the First Amendment. I wish I didn't have to, but I do. Those kinds of decisions do exist. They're not common, and I agree that there is some suspicion that justices and judges will figure the right outcome from their policy perspective and then reason backwards. But that's not what they should do. And overwhelmingly, it's not what they do, because we only see in the popular press the controversial decisions like abortion, like gay marriage. But more than 9 out of 10 cases are, here's what the Internal Revenue Code said for the amortization of a depreciable asset. How does it apply to vineyards? The Treasury Department says it applies this way to vineyards. Is that a reasonable interpretation or not? And there could be, but I doubt very much there is any policy preference by a judge or a justice. So go back to the words, reach the conclusion that the words point you to, and occasionally even when you don't like the outcome. Now, there has been a vibrant debate as to when you go beyond the words. And so is it possible that Congress wrote imperfectly, that a state legislature wrote ambiguously? Yes, of course, every law has an ambiguity in it. And there are cases that I used to teach when I taught legislative interpretation, where the court says Congress could not have intended this. One example was a Seventh Circuit case where the penalty for selling drugs depended upon the weight of the drugs being sold and the vehicle for transmitting the drugs in which the drugs were immersed. So the same amount of LSD would land you a much higher sentence if you mixed it with orange juice and sold it than if you simply put it on a piece of blotting paper and sold it for the exact same amount of LSD. So the Congress eventually straightened that out. But until it did, an appropriate role for the court was to say, could Congress really have intended, although the words seem to say, in measuring the weight of the drug, you include the medium in which it is conveyed. I think the proper outcome there would be to say, yes, Congress said that, so we'll apply that, and Congress should fix it. And the governor, or in that particular case, the president, should commute the sentence of the individual who was given the higher sentence. I'll end with one classic example, which I teach my classes, called Congress Has the Right to Be Stupid. This was the snail darter opinion. So you have a dam that is over 90% finished, pure Tellico dam on the Little Tennessee River, pure energy. It's going to be hydroelectric energy. It's going to replace coal-fired plants. It's environmentally wonderful. And just before the dam is about to go into operation, a snail darter, a small fish, is discovered right by the gates of the dam. And the words of the Endangered Species Act, the Environmental Protection Act, says no project with federal money shall be allowed to proceed if any habitat of any species on the endangered list is negatively impacted. Any. So in an opinion written by Chief Justice Berger, a conservative, he said, Congress, you said it, so we're going to stop the dam, even though it's clean energy, over 90%, and even though this snail darter has a habitat elsewhere, too. We weren't talking about extinguishing the snail darter. A fun aspect of the case, I was clerking that year, is that the Attorney General of the United States, Griffin Bell, argued to allow the dam to go ahead. The EPA argued against it, so you had two agencies of the federal government, the Tennessee Valley Authority, represented by the Attorney General, and the EPA, represented by the General Counsel, two branches of the federal government arguing before the Supreme Court. And the Attorney General, Griffin Bell, began his argument by producing from the pocket of his coat a vial of formaldehyde in which was immersed a snail darter. And forgive my southern accent here, but it helps the story. He said, this whole here case turns on this here little fish, mighty tiny fish, was a mighty big problem. At which point Justice Blackmun leaned forward and said, would the case be any different if it were a large fish? That passes for humor in the Supreme Court. So the opinion of the Supreme Court, stop the dam. And you know what happened? Howard Baker was the majority leader. Tennessee, within 1 year, a special law was passed to allow the dam to go ahead, and the statute was amended. So that's how you respect the way the laws are written and let the Congress correct them if a mistake was made.
So Tom, let me ask you a question that's right on point here. What does a fish say when it runs into a wall? Damn. But at any rate, sorry about that. But there's a sorry, I can see him shaking his head.
You should be sorry.
I'm hoping for
required to have a compulsory chuckle, Tom, and you failed that exam, but I understand. Nonetheless, it was Ben Franklin who famously said, as he got out of this Constitution Hall when they passed the Constitution, that was asked by a woman, what do we have, a republic or a democracy? And he says, you know, it's a republic if you can keep it. But the difference between a republic and a democracy is, I don't remember who made this comment, but that a democracy is two wolves and a lamb deciding what to have for dinner, and a republic gives the lamb some strengthening rights. So it is, in my opinion, incumbent upon really this court system, the judiciary, to protect minority rights, because the executive, candidly, of course, is elected by the majority. The legislature is elected by the majority, but it's the courts that stand up for minority rights. So is that not, in effect, the reason why we still have a republic instead of a democracy? Tom Campbell.
I think it's why we have a viable republic. It's why we have a republic that, despite all of its flaws and criticism, is the envy of the world. That the Supreme Court can 8-0 tell a sitting president that he has to submit personal tape recordings that he created in the Oval Office to a prosecutor who is going to bring them in a criminal prosecution against him. And to the extent that we move away from that, we are at risk. I thought to that point, Chief Justice Roberts was quite right to correct President Trump when President Trump referred to Obama judges and Clinton judges, and Chief Justice Roberts himself, a Republican appointee, said there are no Obama judges, there are no Republican judges, there are no Democratic judges. They're federal judges, each of them attempting to do her or his best.
Some of that gets back to the question that Bijan had about the way we now nominate and then evaluate nominees to the Supreme Court in the United States Senate. I'd like to bring a couple of issues together. Tom, you also said a few minutes ago that most of the cases are not that controversial, and I think it's around 80% of the United States Supreme Court decisions are unanimous or near unanimous. It's the controversial ones that end up being 5-4 decisions. And that's why the Senate is so careful in how they evaluate nominees. It seems when the court gets in its most controversial position is when it seems to go ahead of the not the legislature, ahead of the culture. For example, you mentioned the gay rights issue. States were already moving in that direction. In the area of abortion, states had different laws impacting abortion rights. And regardless of how one feels about either of those issues, it seems that when the court gets in front of the culture, not necessarily in front of law, but in front of the culture, that's when the court becomes most divisive and most controversial. And when you look at abortion, there's nothing in the Constitution about medical procedures at all. And even many pro-life or pro-choice legal authorities believe the court wrongly decided it because that was probably the preeminent example of making law. But ever since then, every time there's a nomination of the Supreme Court, that's the underlying issue. So could you address those two things? One, was Roe versus Wade making law? And secondly, what about the contentious way that we now evaluate judges for the Supreme Court?
Roe versus Wade interpreted the phrase of denying a woman life, liberty, or property without due process of law to incorporate the concept of liberty. It ignored the concept of life by the child or fetus. I'm not trying to pitch the argument one way or the other by my terminology, so choose whichever word you prefer. But if a state hospital performed an abortion, there is no question that an issue of whether they had terminated life was presented. And so you have it's not even as simple as the complex issue that you described, Joellen. It is even more complex because you have two rights. You have, if the action is done by the state, you have the right to life, and you have the right to privacy. So where you have an interpretation that comes down, closes off one possible interpretation, and does it under the Constitution, you short circuit the potentially very beneficial process of working out a compromise. The problem with the use of the Supreme Court in resolving that was that it closed the door to medium compromises in the middle. I'll give you an example. It's one I've advocated for some time, and again, it's in my textbook. Suppose Congress or the states, individual states, passed a law saying that a woman shall have the right to abortion for up to 1 month after she knows that she's pregnant, but not thereafter. And then possibly except where her life or serious mental or serious physical health is at risk. And where a woman is incompetent to know whether she's pregnant or not, then the court will order a guardian, as they do in cases of incompetence. The problem, now that might seem a sensible solution.
But isn't that what the court? But isn't that what the court did, though, when they divided pregnancy into 3 trimesters? Isn't that essentially what they did?
No, the way I phrased it was 1 month after the woman knows or should know she was pregnant. The Supreme Court in Roe said first trimester, which is not the same as 1 month after a woman knows that she is pregnant. And furthermore, during the second trimester, the only basis that the state can use to restrict the woman's right to choose, as interpreted in Roe v. Wade, is the medical, the safety of the mother, not concern over the child or fetus, once more, depending on your phrase. But your question is very helpful in elucidating just this point. Are there reasonable middle grounds? Yes, there are reasonable middle grounds. But if the Supreme Court has said the woman's right cannot be compromised in the first 2 trimesters, except in the second trimester only for health, you don't reach a possible balance between the right of the child and the right of the woman. And that's what the legislative process in the various states was tending towards. That's where it would have gone. And similarly, I think would have gone in regarding gay marriage. So the difficulty of the using the Supreme Court is that they have a blunt instrument. It's constitutional or not. They cannot say, at least admit that they're saying, we don't like this outcome as a policy matter, hence we're ruling against it. They have to say, if we're ruling against it, it is unconstitutional. And bang, that closes the door. What I put forward, I believe, might actually be a compromise that a majority of Americans could agree with. Women get pregnant and don't necessarily know the consequences, don't necessarily agree at the time or without it being actual rape. There's many circumstances. So why don't we just make this bright line rule by legislation, see how it works out. Can't do it. Supreme Court has taken the ability of compromise away. And then you asked, why are Supreme Court hearings on nominees so contentious? Well, precisely because the court has used the phrases like the due process clause, or on the conservative side, privileges and immunities. So the Constitution also says that the federal government nor the states shall deprive any citizen of the privileges and immunities of citizens of the several states or citizens of the United States. And on the conservative side, that has been argued to say, well, that means the right to contract. So the state cannot interfere with my right to contract. And if I want to work for more than the maximum number of hours in a day, I should be allowed to do so. Where does a state have the authority to stop me from contracting to work for 12 hours instead of 8? So because the court has become this vehicle for interpreting these phrases in a way that shows policy preferences, as opposed to a way that shows deference to the 2 other branches that are supposed to deal with policy, the hearings have now become surrogates for decisions on policy. And you and I, all of us on this panel today, have heard senators say, well, and presidents say, I will not nominate or I will not confirm somebody who doesn't promise to uphold Roe versus Wade, or occasionally who doesn't challenge Roe versus Wade. No, that seems to me to force a judge or a justice to say, I promise in advance to decide a case a particular way, no matter what the evidence and the facts before me and the court and the argument is presented to me. My gosh, do you really want to do that to a judge or a justice? Say, I hereby promise that I will not take into account all of the facts and all of the law as presented to me as of the day of the argument. I'll conclude with a bit of nostalgia. As Judge Gray pointed out, I had the tremendous honor to clerk for Justice White. When Justice White was nominated in 1963, His hearing before the Judiciary Committee lasted 2 hours, and he was then confirmed by voice vote the next day. He was asked by a reporter, what's the purpose of, what do you think the function of the Supreme Court justice is? Just think for 2 seconds what you might answer to that question. I tell you, I might have been tempted to say something grandiose, like to do justice, to show no impartiality, to advance the cause of individual liberty, something which I believe in. Instead, Justice White said, the purpose of a justice is to decide cases.
He's right.
In other words, Smith versus Jones. Somebody owns this property. Is it Smith or is it Jones? Well, we'll decide the case.
Well, that's what,
And so,
that's what Chief Justice Roberts said too. You just call balls and strikes. But I'm here to be blunt again, and maybe I should be more deferential. But life is complicated. You're not telling us that, are you, Dean Campbell? And also, yes, due process of law. What does that mean? Well, in the eye of the beholder, sometimes we haven't even spoken about the phrase in the Constitution that Congress can pass any laws necessary and proper to enforce what we're talking about here. But there was a justice, I don't remember his name, but I'm sure, Tom, you will, who said that the Supreme Court, we in the Supreme Court are not last because we're infallible. We're infallible because we're last. And there's a lot to that. It comes a time when you simply have to jump and hope there's water in the pool. You have to decide things and move on. But you recommend
jump. Congressman Campbell, I have a question that I'm sure it's on the minds of our viewers as well. It's about court packing. It sounds derogatory by those who oppose it. I'm sure those who advocate for expanding the number of justices on the Supreme Court don't call it court packing. Only those who oppose it do that. I want to ask you this question: why people have an opposition to expanding the seats, and what is intended by those who advocate for it? What do they hope to accomplish? And both sides, those who advocate for it, what's the reason? What do they want to do? And those who don't like it, why don't they like it?
And has it ever been attempted?
Twice, and it succeeded once. And the policy purpose is why court packing is wrong. If I wish to increase the number of justices so that my side can put more justices disposed to my policy position, because sadly, we recognize Judge Jim Gray's observation that justices might be reflecting their policy views, then that's court packing. If by contrast, the court's workload, the necessity to have an odd number of justices to decide a case, when we started, we had only 6. We had an even number of justices on the Supreme Court. So those are reasons neutral to the outcome. And the number of cases coming up to the Supreme Court is increased over the years. So more justices, and perhaps they should sit in panels. Perhaps they would rotate off after 15 years. Those are all perfectly appropriate issues. The latter would require a constitutional amendment. So what is court packing, and why is it a concern for those of us who respect and want to promote the neutrality of the Supreme Court? It's because you're adding justices in order to get the result. So the Democrats at the moment have threatened, gratefully President-elect Biden has not said, but others running against him did, that if Justice Barrett was confirmed, as she was, that the Supreme Court should then add 4 more justices. So those 4 more justices would be appointed by President Biden. They would be confirmed, they believe, by a Democratic Senate. And then you would have 7 to 6, liberal to conservative. Right now, you might call it 6-3, conservative over liberal. So that's court packing, where you add justices in order to get the outcome you want.
Do they admit that? Do people who advocate for such an act, do they admit that they're desirous of expanding the seats so that their side has more or stronger representation? Are they willing to admit that?
Yes, Bijan, it's because it's embarrassing to deny it. Nobody is proposing this after an engineering study of the optimal number of justices. So no, there's no hiding the ball. This is what's intended.
Tom, when the Republicans get back in, then they would appoint another 2. So then we'd have 15, and then it would go back and forth. Libertarians, by the way, would not do that, I'm proud to say. But I have, you made a suggestion with regard to constitutional law interpretation. I have one with regard to an amendment that you just touched upon, which is, I think that we should have a constitutional amendment saying, okay, only 9 justices on the United States Supreme Court. And by the way, they would have term limits of 15 years, I would think would be fine. And that would keep presidents, for example, and Clarence Thomas, whom I agree with a lot of the time, but no one who's only 40 years old should be appointed to the United States Supreme Court, in my opinion. Why did George H.W. Bush do it? Oh, because his legacy would continue on for maybe 40 years. But if there were a term limit for being on the United States Supreme Court for 15 years, then someone maybe like 55, 58 would be appointed, and it would get away from that. Plus, you wouldn't have justices, maybe Ginsburg, trying to stay on the Supreme Court, even though maybe she wasn't able at the end, because she didn't want a Republican to appoint her successor, but they would start doing away with that. So would you support the Gray Amendment to the United States Constitution for term limits and setting the number at 9?
I think the Gray Amendment is correct. I would indeed support it. And let us be clear, that's a constitutional amendment. You would have to obtain 2/3 of the House, 2/3 of the Senate, and 3/4 of the states to go along with it. And it would not be to bring about a particular outcome. Think of Oliver Wendell Holmes, one of our great justices, appointed by Theodore Roosevelt when Holmes was 60 years old. That would be highly improbable today. He served till he was 90, so he didn't actually have a short tenure. But the preference, of course, is for justices in their 40s. So yes, those steps would be beneficial, salubrious, and unrelated to the policy outcome. A couple of quick additional points. If we got to you get 2 more, we get 2 more, eventually the size of the Supreme Court would grow, simply to reflect whichever party controls the Senate and the presidency. The Democrats who are arguing this now argue the Merrick-Garland case as the reason. They say, well, the Republicans stole a seat because they should have allowed a vote on Merrick-Garland. No, I agree they should have allowed a vote on Merrick-Garland, but that is not a legitimate reason to pack the Supreme Court. And it wasn't stealing a justiceship. In fact, in Marbury versus Madison that we spoke before, the whole premise was the following. People forget this in history, but John Adams was defeated by Thomas Jefferson in the election of 1800. So after the election and during the lame duck session, while John Adams' party was still in charge of the Senate, the Federalists, they appointed over 40 new judges, created the vacancies, and then appointed to them in the lame duck session. So not that we should emulate that, but it's not unprecedented. Lastly, I did want to say that in the debates, Vice President-elect Harris said that President Lincoln had not went ahead to replace Chief Justice Taney when a vacancy was available because it was too close to the election. She is right as to the history, but wrong as to the reason. Lincoln did not want to make a Supreme Court appointment at issue in the 1864 election. So it wasn't that he believed the proximity of the election deprived him of the right. It was a pure political, pragmatic judgment. And Abraham Lincoln, for those who studied his history, know he was quite a pragmatic president. Only 3 years later, however, the president of the United States was Andrew Johnson, a Democrat who had run with Abraham Lincoln on a fusion ticket in 1864. So a Democratic president had the power to appoint. The Republicans controlled the Senate, and they announced that the number of justices would be decreased from 10 to 7. And then, since they had 10 at the time, Andrew Johnson would thus be able to appoint no more justices until the number came down.
And I believe in the Lincoln situation, the Senate wasn't even in session anyway, so they couldn't have confirmed a nominee. But
he would have had to call them back.
Exactly.
He would have had to call them back. Yeah.
Well, we have had a wonderful session with and he's lived up to the billing from my standpoint, and I'm sure from our audience. So thank you, Your Eminence. I appreciate your sharing your insights with us. This is our 6th session talking about the judiciary. 5 weeks from now, Congressman Campbell has agreed again to be our guest, and we'll talk about the separation of powers. So thank you for that. And Tom, thank you just personally as well as professionally, as well as, of course, to my co-host for doing this. And just a reminder, Tom Campbell is the author, he mentioned it, of the book, Separation of Powers in Practice. So he isn't not just an intellectual, he's also very practical minded. So I commend this to you. Also, by the way, next time in our 7th session, we will have our guest, Dr. John Kaminsky, who happens to be the founder of the Center for the Study of the American Constitution. That is not a coincidence, but we're going to be talking with Dr. Kaminsky, and that I'm sure you will want to join us. In the meantime, if you wish to listen to the other songs, either again, this one, Remember the Ladies, Abigail Adams Still Lives, or any of the other songs, go to my website, it's judgejimgray.com, click on musicals, click on convention, and you can hear any of these 17 songs. It's not cheating to do it. You can go back, you can go forward. You have all of our permission, as well as if you just like to have information about the day-to-day workings at the Constitutional Convention back in 1787. Joellen Chatham knows a great deal about this, and it's also on the website. You log into the Center for Public Policy at Concordia University in Irvine, California. So with that, thanks again to our guests. Thanks to our co-hosts. Here it is from Independence Hall in Philadelphia. We wish you the best. Life is good, and we hope to see you again next week. In the meantime, be well and enjoy.